Good afternoon and welcome to our third session in relation to medical practices put on by DW Fox Tucker Lawyers. My name is Ben Duggan. I'm a director in the employment team, and today I'll be talking about Labor's workplace relations reforms and providing specific information as to how those reforms have an impact on medical practices. In terms of the genesis of these reforms, in the lead up to the last election, the ALP opposition put out its workplace relations reform policy. And of course, the ALP formed government in May of 2022 under the Prime Ministership of Anthony Albanese. The Labor Party has come to power on an interventionist platform, the likes of which Australia has not seen at a federal level for many decades. In the area of industrial relations, Labor had promised under its policy that it took to the election to introduce greater regulation. The greater regulation would propose amendments to its industrial relations laws, in particular its Fair Work laws, that were designed to achieve its goals of higher wages through changes to enterprise bargaining rules, closing the pay gap between men and women through several measures, and the reduction of insecure work through the regulation of various labour options, including casual employment and fixed-term employment arrangements. Labor, with the support of the Greens, was able to pass its bill to amend the Fair Work laws known as the Secure Jobs Better Pay Bill in late 2022. Significantly, each aspect of that act commenced on a particular date. That is, it does not all commence to operate from the date that the bill received royal assent, as we shall discuss today. Labor did not stop at this point, introducing its Closing Loopholes Bill to federal parliament last year. Key aspects of the Closing Loopholes Bill were more changes to enterprise bargaining rules, greater rights for union delegates and union officials, further regulation of insecure work, including the insertion of a definition of casual employment, and changes to compliance requirements, including higher penalties for underpayment of wages. The Closing Loopholes Bill, as we would all know, was split into two parts, with Part 1 being passed late last year and Part 2 being passed last month. These reforms are the most significant permanent changes to the federal industrial relations system since the introduction of the Fair Work laws back in 2010. My focus today will be on the reforms that have an impact on the medical industry, particularly those directed towards the regulation of your labour force and compliance. In terms of the Secure Jobs Better Pay, which was the first part of the industrial reforms introduced by Labor, one of the things that they changed was to introduce a new Fair Work objective into the Act. The objectives are set out in Section 3 of the Act, and they include providing workplace relations laws that are fair to working Australians, ensuring a guaranteed safety net, ensuring that that safety net is fair and reasonable, achieving productivity and fairness, and acknowledging the special circumstances of small and medium-sized businesses. The objects, on the one hand, reflect the need to provide a legislative framework which is flexible for businesses and promotes productivity and economic growth, and on the other, the desire to ensure that the framework is fair and protects the rights of employees to guaranteed safety nets, flexible working arrangements, and fairness of representation at work. Labor, through these reforms, has introduced a new objective, which is job security, as the name of the Act indicates. The change to include job security as a new object is significant because it means that the Fair Work Commission must consider this issue in all of its decision making, which includes the federal annual wage review. Now, in relation to that review, it seems to me that business groups might argue that the aim of job security might in some way affect the amount of any minimum wage increases in the future. In particular, it could be used in arguments to suggest that they should be moderated in order to achieve that aim. And we'll see whether or not that argument is put forward in the coming weeks as the Fair Work review is undertaken by the Fair Work Commission. The other significant aspect that was the aim of Labor and its policy was equal pay. And in relation to that, the government has introduced reforms which enable the Commission to make determinations on its own initiative that consider work value reasons that must be free of assumptions based on gender and include consideration of whether historically the work has been undervalued because of assumptions based on gender. The aims of these reforms is to provide a more effective mechanism to close the gender gap. The Fair Work laws previously allowed the Commission to make a determination bearing modern award minimum wages if it was satisfied by work value reasons that there was discrimination that was occurring. The reforms allow the Commission to make such determinations, as I've said, on its own initiative, with their considerations of work value to be free of assumptions based on gender and include consideration of whether historically the work has been undervalued because of assumptions based on gender. And if those criteria are met, the Commission is able to make decisions, as it has done in relation to some recent test cases, to increase the wage of those employees covered by the relevant award that they're considering. The other mechanism that was used by the Labor government to seek to address the gender gap was the removal of pay secrecy from contracts of employment. And a pay secrecy clause was a common inclusion in contracts of employment prior to these reforms. The clause would generally provide that an employee's remuneration was confidential and prohibited them from disclosing, discussing or comparing salaries with other employees in the business. Breaches of those clauses have previously seen employers have a valid reason for termination. However, Labor's reforms now make it a workplace right for employees to be able to disclose or not disclose information regarding their remuneration. By making this a workplace right, it means that employees are protected from having adverse action taken against them for making such disclosures. Further, employers are now entitled to make general protections claims if their employer takes adverse action against them for having exercised this workplace right. Employers will therefore, if they haven't already, need to review their contracts of employment to ensure that they no longer contain these pay secrecy provisions. The other thing that has occurred through Secure Jobs Better Pay is that there's now a prohibition on job advertisements which don't include minimum rates of pay. So any job advertisements where the rate of pay is indicated in the job advertisement that's less than minimum rates of pay, either the national minimum rates of pay or award minimum rates, contravenes a breach of the Act. The other significant change was that there was the introduction of prohibition of sexual harassment in the workplace. Now, sexual harassment has been something that's been prohibited for some time. That legislation, though, was sexual harassment and discrimination legislation itself. And there hasn't been a prohibition of sexual harassment in the workplace in the Fair Work laws until these reforms. And that is now a prohibition contained in the Fair Work laws, and the protection extends to all workers, which includes employees, contractors, subcontractors, outworkers, apprentices and the like, which is a similar definition to the definition that's been used in work health and safety laws for over a decade. So workers, prospective workers and persons conducting a business or undertaking will each now be able to seek remedies under Fair Work laws to ensure that sexual harassment is not taking place in the workplace. Significantly, the reforms enable the Commission to deal with sexual harassment by continuing to provide for mechanism for workers to seek a stop sexual harassment order, similar to the bullying orders that can be sought at the moment, and dealing with the dispute and ordering compensation to remedy past harm caused by sexual harassment through mediation and conciliation. If the matter remains resolved, the parties can consent to arbitration before the Commission or alternatively refer it to a federal court. Central to these changes, the ability for applications to be made jointly by multiple agreed parties, as well as by a union, as opposed to a single individual. This will enable the Commission to deal with multiple parties together if it is appropriate to do so. For example, where there is a common perpetrator at a work location where the sexual harassment has occurred from a practical perspective. The other thing that has happened has been, through these reforms, the extension of unpaid parental leave. So the parental leave right, which has been a long-standing right of 12 months of leave, has now been extended as of right. Many employers would extend parental leave as a matter of course if that was requested by their employee, but now it's actually a right that employees to have an extension for a further period of 12 months. So in effect, the right now is the 2-year right rather than the former right of 12 months. In addition to that, the reforms have introduced broader options in relation to flexible work. So they amend the rules relating to requests for flexible work arrangements and introduce new provisions empowering the Commission to resolve disputes regarding such requests. So in terms of the scope of the reforms, they of course build on existing rights to request flexible working arrangements under the Fair Work laws by expanding the circumstances in which an employee may request flexible work arrangements to include situations where an employee or a member of their immediate family or household experiences family and domestic violence. In terms of the obligation, the reforms also insert a new section which require an employer who receives a request to meet the employee to discuss their flexible work request. Where the employer intends to refuse the request, agree upon alternative changes if they are reasonable, and if the employer still intends to refuse the request, outline the employer's reasonable business grounds for that refusal and address the following: changes to the employee's working arrangements that would accommodate to any extent the employee's circumstances, or that there are no such changes the employer could make to accommodate the employee's circumstances. In addition to that, the reforms enable a dispute mechanism. So for the first time, the reforms introduce a mechanism for circumstances where an employer has refused a request or not provided a written response as required, or the parties are unable to resolve the dispute through discussion at the workplace level. So the new provisions stipulate that where a flexible working arrangement dispute arises, conciliation should be the first avenue of dispute resolution, but where that is unsuccessful, then the Commission does have the power to deal with the dispute as it considers appropriate, which might mean mandatory arbitration. In terms of the options for the Commission in relation to such arbitration, they could make an order that the employer be taken to have refused a flexible work request. Where an employer has refused a request, an order that would be appropriate for the grounds on which the employer refused the request as reasonable business grounds, or an order that the employer provide the employee with a written response to their flexible work request. Orders under this section cannot be inconsistent with the Fair Work Act. So medical employers may need to review their management of flexible working arrangement requests. In particular, that will be necessary to discuss such requests with an employee when it was received in accordance with the reforms. The other issue of significance under the reforms is the regulation of fixed-term contracts, and this came into effect late last year. What Labor's reforms do is they introduce provisions that limit the use of fixed-term contracts for the same role to 2 consecutive contracts or a maximum duration of 2 years, subject to certain exceptions, which we'll discuss in a moment, and convert fixed-term contracts to permanent employment contracts in certain circumstances. The prohibitions and regulations apply to both fixed-term and outer-term contracts, that is, a contract with an expiry date, but with a general right to terminate prior to that date. In terms of the prohibition, the engagement under the contract is for a period of greater than 2 years, including any extensions or renewals. The employee has been engaged on consecutive fixed-term contracts, and the employee's total engagement on the contract is greater than 2 years, or one of the contracts contains an option to renew or extend the contract. For a contract to be a consecutive fixed-term contract, the employee must be engaged to perform the same or substantially the same role. As I said, there are a number of exceptions to the fixed-term prohibition, which effectively limits it to a maximum term of 2 years. They are to perform only a distinct and identifiable task involving specialist skills, to perform essential work during a peak period, a training arrangement or government funding arrangement. The employee earns above the high income threshold. It is an appointment to a governance position. It is wholly or partly government funding, or a modern award permits the use of fixed-term contracts, which seems a bit unusual given the new aim of the Fair Work Act to provide job security. So it wouldn't be expected that a modern award would permit a fixed-term contract beyond the 2-year point. In terms of compliance, employers are now required to provide employees with a fixed-term contract information statement before or as soon as possible after the contract is entered into between the parties. So medical practices in the future, when they're engaging parties on a fixed-term basis, will need to ensure that this new statement is provided at the time of the engagement or shortly thereafter, and will need to ensure that they don't fall foul of the requirement to have a maximum term of 2 years for such fixed-term arrangements. The other thing that happened late last year as well is there was a sunsetting of what had been described in the Act as zombie agreements. Now, these zombie agreements were any enterprise agreements that were entered into prior to the Fair Work Act in 2010. The effect of the reforms was effectively to set a sunset date on those agreements of December last year. That date has come and gone, so unless a party has applied for an extension of these zombies agreement and granted that extension, which was only available in fairly limited circumstances, those agreements have now come to an end, and the modern award, the relevant modern award, now applies. So if you've got if you're a medical practice and you did have one of these zombie agreements and nothing is done to extend it, those agreements have now come to an end, and subject to any contractual arrangements that you might have, you should be paying in accordance with the modern award. So as I said earlier, Labor didn't finish its reform agenda at the conclusion of its secure pay, better jobs reforms. It continued on and proposed further changes to the loopholes bill. The bill was split, and Part 1 was passed late last year, and Part 1 introduced a series of amendments to the Fair Work laws. The more controversial amendments of the Closing Loopholes Bill were split off to be dealt with at a later point in time, and indeed they have been dealt with, and the reforms for Part 2 were passed last month. And I'll focus in my discussion on those changes that have most effect on medical practices. In terms of regulation of labour hire, Labor's Closing the Loop reforms include the implementation of the principle of same work, same pay for labour hire workers. So what the reforms do is that they enable the Commission, and who may receive an application from either an employee, union or the host employer, to make an order that labour hire employees must be paid at least what they would receive under a host enterprise agreement or equivalent public sector determination. Such an order must only be made if the Commission is satisfied that the work to be performed for the host employer is for the supply of labour rather than the provision of a service. That's intended to avoid a situation where genuine third-party contractors are providing a service to a third party rather than a situation where it's a true host-employer situation. The Commission must also not make an order if it is not fair and reasonable in the circumstances. My view about these changes is it's rather clumsy in the sense that what the regulation does involve is it requires an application to the Commission. So in that sense, it may not have a significant practical impact, but I'll discuss what might have in the future later on in my presentation. There has been some new family and domestic violence protection, so the stronger protections against discrimination against employees who have been or continue to be subjected to family and domestic violence under the reforms. In addition to that, there's some changes to the small business redundancy payment exemption. So at the moment, under the National Employment Standards, a small business employer, which is up to 15 employees, is not required to pay redundancy pay. But what Labor is seeking to address here is that it may well be that an employer is a larger employer and through redundancies becomes a small employer, and looking at those circumstances and seeking to adjust it such that if it's one of those situations where there's a closeness in terms of proximity of time between becoming a large and a small employer, that they're still obliged to make a redundancy payment. So there's some specific criteria that apply in relation to those changes, but that would be something you'd need to get advice about if you're on the cusp of having 15 employees. Some of the more significant changes that have got some publicity in relation to the closing loop changes is, of course, the criminalisation of what Labor has described as wage theft. Labor's reforms criminalise wage theft for the first time at the federal level. Now, this is not the first attempt that a federal government has sought to introduce the criminalisation of wage theft into the Fair Work Act. Prime Minister Scott Morrison and his government had previously sought to introduce this into the Fair Work Act unsuccessfully several years ago. And in response to that, a number of states, including Victoria, had moved towards the criminalisation of wage theft at a state level. They are now looking at removing their provisions in recognition of the fact that the reforms have been introduced at a criminal level. So the offence of wage theft will apply to employers who intentionally engage in conduct that results in the underpayment of their employees. These offences apply to employee entitlements under the Fair Work laws, a modern award or enterprise agreement. They don't apply to solely contractual entitlements. So by way of example, if you have a termination of employment situation where you've made an employee redundant and under their contract of employment, they're entitled to 3 months' notice, but you only pay them 5 weeks' notice in accordance with the National Employment Standards, that would not amount to wage theft because it's purely a contractual entitlement. That is the balance of the 2 months is purely contractual entitlement. The offence will cover intentional underpayments of superannuation contributions in certain limited circumstances. In terms of the penalties for the new wage theft offence, they are significant. They involve a maximum of 10 years imprisonment and or a maximum fine of the greater of 3 times the amount of the underpayment if the court can determine that amount, or for a company that is an employer, a maximum amount of up to $7,825,000. So you can see that this is a fairly significant uplift in terms of the penalties that previously applied, and the approach, as we'll see, which comes out in relation to other offences, is the concept of the penalty being 3 times the underpayment. And that certainly comes off the back of a view that's been held in the Labor movement for some time, that the penalties didn't appropriately reflect the offence. where an employer is found guilty of committing 2 or more offences that arose out of the same conduct. For the purpose of sentencing, the person will be taken to be guilty of a single offence. The Fair Work Ombudsman will be primarily responsible for investigating the new criminal offence. They will have the option to refer matters to the Commonwealth DPP or the Australian Federal Police for consideration and prosecution where appropriate. Significantly, under these reforms, there has been some safe haven arrangements that have been inserted into the Act, and these are significant. So the reforms provide a pathway to encourage employers to self-disclose conduct which might otherwise amount to the commission of a wage theft offence to the Fair Work Ombudsman. In return, employers would not be referred by the Fair Work Ombudsman for criminal prosecution for wage theft, and these pathways include a voluntary small business wage compliance code, which will be developed by government in partnership with employer and employee groups, and evidence of compliance with the code will ensure that the Fair Work Ombudsman will not refer conduct for criminal prosecution. The second possibility is the option for the Ombudsman to enter into a cooperation agreement with an employer if they disclose that they have engaged in conduct that may amount to the commission of the wage theft offence. So those 2 options are significant, and they, of course, in relation to the second option, involve the employer disclosing it to the Fair Work Ombudsman before the commencement of investigation or prosecution in relation to the matter. The other comment to make is, of course, this doesn't deal with the underpayment itself. The employee, the Fair Work Ombudsman or a union may still take action in relation to the underpayment itself. This is only addressing the issue of the penalty itself. The other significant change that has been introduced, again, for the first time at a federal level, is industrial manslaughter. Labor's reforms introduced the criminal offence of industrial manslaughter to the model Federal Work Health and Safety Act. That Act, of course, has been replicated in each of the different states where safety is still regulated by state parliament, and the state Labor government here in South Australia has updated our local Work Health and Safety Act to include the criminal offence of industrial manslaughter to ensure that it remains consistent with the model Federal Act. In terms of the offence, a PCBU, language you'd be familiar with, being the person in control of a business or undertaking or an officer, commits the new offence where their breach of a safety duty that causes death arises from conduct that is either gross negligence or reckless. And if that criteria is satisfied, the new penalty regime under which a PCBU, which is normally a corporate employer, faces fines of up to $18 million, whilst individuals, which you're normally thinking about a director, faces a maximum prison sentence of up to 20 years. This, of course, applies to the new offence of industrial manslaughter. There are other offence maxims that apply to other lesser offences under the Act. I now turn to Part 2 of the Closing Loopholes Bill. Excuse me, that was passed last month. Part 2, as discussed, contains some of the more controversial elements of the Closing Loopholes Bill. The first one, which wasn't overly controversial, but higher penalties for underpayment. Now, we've just dealt with a moment ago the new offence of wage theft. This is simply for a general penalty. So the reforms contained in Part 2 of the bill have, just for good measure, increased the penalties for general contraventions related to underpayments of employee entitlements, with maximum penalties now being increased by 5-fold. So the maximum penalties now for a general contravention is for the company employer $469,500, or 3 times the amount of any associated underpayment. So you can see again that concept of 3 times the underpayment coming into the general contraventions. For serious contraventions, maximum penalties will increase to the greater of, for a company employer, $4,695,000, or again 3 times the amount of any associated underpayment if the applicant seeks this kind of penalty. So you can see now in terms of penalties for underpayments, there's really now 3 levels. So you have the wage theft at the highest, you have serious contraventions, and then you have the general contraventions, each with their own penalties, but each significant enough, certainly in relation to the general contravention, which is at the lower level. You're still looking at nearly $500,000, or 3 times the amount of any associated underpayment, which is a significant penalty for any company to face. In terms of other changes, there have been some independent contractor changes associated with gig works, which is not going to have any impact on medical practices, so I don't propose to spend any more time on that. The other issue, again, which is not going to have any practical impact on medical practices, relates to changes made to intractable bargaining, which enable the Commission to have a greater involvement where parties are unable to successfully negotiate an enterprise bargaining agreement. Some of the other significant changes which do have an impact on medical practices relate to some new definitions that have been inserted into the Act. The first of those is a new definition of employee under the Fair Work laws. A key long-term trend has been the rise in Australia of the use of independent contractors, including gig workers. Independent contractors have different rights and obligations to employees, and they certainly don't have any rights under the Fair Work Act to the National Employment Standards. Traditionally, courts have looked at the whole relationship between the parties, known as the multi-indicia test, when determining if a worker is an employee or an independent contractor. Now, these disputes may arise in a whole range of different contexts. They may arise when a worker is injured, who's been engaged as an independent contractor and seeks benefits as an employee under workers' compensation law, or they might arise at the end of the relationship when the worker who's been engaged by an independent contractor seeks to assert that they were truly an employee and entitled to employee entitlements under the NES. The multi-indicia test involved a consideration of the totality of the relationship between the parties to determine whether a worker was an independent contractor or an employee. Factors considered as part of that test included the written contract, the degree of control that the engaging party had over those that they were engaging, the remuneration, including any loading, invoices, registration for GST, and whether tax is withheld, and who decides the hours of work, pattern of work, and what obligations they have to work. In early 2022, the High Court handed down 2 very significant decisions about independent contractor relationships in the matters of personnel contracting and ZG Operations Australia. The High Court in those decisions took a different approach and distanced themselves from the multi-indicia test in the determination of whether a worker was an employee or an independent contractor. In doing so, the High Court made it clear that the critical issue is the party's description of the relationship, in particular through any written contract that existed between the parties. Now, the practical effect of these 2 High Court decisions was it became difficult for workers who were engaged as independent contractors but believed that they in truth were employees to seek employee entitlements in a court or a tribunal based upon their view as to the real status of their relationship. Labor's reforms, though, introduce a definition of employee into the Fair Work laws that is different to what previously existed. The definition involves an assessment of the real substance, practical reality, and true nature of the relationship between a worker and the party that engages them to perform work. The reform replaces the new High Court test, which emphasised the contract between the parties, with the traditional multi-indiciate test, which considers a range of factors in the determination of whether a worker is an employee, independent contractor, or employee. The effect of this change, in my assessment, is that it's more likely in these disputed situations that a worker would be able to successfully argue that they were in truth an employee, even though they'd entered into a written contractor arrangement. Other changes related to this issue include changes to sham contracting. Employers who have incorrectly classified a worker as an independent contractor may be penalised for sham contracting unless they can use the amended sham contracting defence. The new defence provides that an employer has not contravened the sham contracting provisions if, at the time of the representation, that is about the nature of the engagement, the employer reasonably believed the contract of employment was a contract for services, that is, an independent contractor arrangement. Prior to this change, an employer needed to prove that they did not know and were not reckless as to whether the contract was an employment contract rather than a contract for services. So you can see with that change, the defence has changed, and it's going to be more difficult for employers to rely upon that defence in the future. In addition to that, there have been some changes in relation to unfair contract terms. So there's been a new framework that has been established for independent contractors to set aside perceived unfair contract terms in independent contracts. Under the framework, independent contractors with income below the contractor high income threshold, which is to be prescribed in regulations, will be able to apply to the Commission for orders to have all or part of our independent contractor agreement set aside. The amendment introduces another set of broad multi-factor criteria for determining whether a contract is unfair, and it's not limited to the respective bargaining power of the parties as to whether the terms are deemed to be unreasonable to protect the legitimate interests of a party to the contract. When dealing with these disputes, the Commission may choose to either conduct a private conference to deal with the matter or proceed to a hearing, having regard to the views of the party and the most effective and efficient way to resolve the matter. So for medical practices who regularly engage workers, in particular doctors and specialists as independent contractors, it's appropriate in light of these reforms, including as to the defence in relation to the sham arrangements and unfair contract term jurisdiction, to review their contracts in light of these reforms and adjust them as necessary to respond to these reforms. Further to that, there's a new definition of casual employee under the Fair Work laws. The new definition of employee is supported by this new definition for casual employees. Again, the definition for a casual employee, in the same manner as that for employee, considers the practical reality of the employment relationship as opposed to merely the terms of the contract. The new definition of casual employee is that the employment relationship is characterised by an absence of a firm advance commitment to continuing and indefinite work, and the employee is entitled under a Fair Work instrument or contract of employment to a casual loading or specific rate of pay for casuals. So it's not much of a change to what's previously existed in place, though again, we're moving away from the emphasis on the written contract of employment. Indicators for assessing whether there is a firm advance commitment includes consideration of the real substance, practical reality and true nature of the employment relationship, and other factors. The departure from the terms of the employment contract as the primary indicator of casual employment may afford employers less certainty when defining their employment relationship with casual employees. Employers must actively assess the practical realities of the employment relationship to avoid improperly classifying their casual employees. For medical employers who engage workers as casuals, it would be appropriate to review their contracts of employment, but also paying particular attention to the practical arrangements that they have to ensure that the worker that they're engaging is truly a casual employee of the practice to avoid difficulties down the track. In addition to that, the reforms make some changes to the casual conversion rights that had previously existed under the Act and modern awards. The reforms remove existing casual conversion provisions and replace it with a similar but separate employee choice framework. Casual employees may now give an employer written notification if they would like to change their employment status to permanent after 6 months of employment or 12 months for a small business. Employers will be required to respond to the written notification from casual employees within 21 days after the notification is given, and employers must comply with a range of form, content and notice requirements for a response to be properly provided. The Act provides that the employer may not accept the employee notification if the employee meets the definition of a casual employee. There are fair and reasonable operation grounds for not accepting the notification, or accepting the notification would result in the employer not complying with recruitment or selection processes required by Commonwealth laws. The new employee choice pathway differs to the previous process of casual conversion. Now, it is up to the employee to initiate the shift to permanent employment, as opposed to the employer, who is required to review their casual workforce and offer casual conversion where appropriate in accordance with the old regime. Employees can also only now assert permanent employment after their job has already been ongoing, forming a stricter test than under the casual conversion provisions, which only required casual employees to be working on a regular basis for 6 or 12 months. In practice, it will be appropriate for medical practices to consider during the course of employment of a casual employee the issue of whether or not an offer of permanent employment should be made, and that decision should be made on a regular basis, at least 12 monthly. In terms of disputes, at the first instance, the reform requires that the parties to the dispute attempt to resolve the dispute as to a casual conversion at the workplace level. However, again, if the dispute cannot be resolved, the Commission has powers to resolve the dispute, including arbitration as a last resort. With the removal of the casual conversion provisions and the introduction of this employee-led employee choice pathway, there are less stringent requirements on employer to review their workforce and proactively offer permanent employment. Instead, as indicated, employers will only need to take action when they receive an employee choice notification. The other change made under the reforms is the timing in relation to the provision of casual employment information statements. Previously, they were only required to be provided upon commencement of employment. Now what will happen is there is now an additional requirement that employees will need to be provided with them after each 12 months of employment. And employers who are not small businesses will also need to provide the statement at 6 months from when the employee commenced employment. So medical practices will need to ensure that they comply with these compliant obligations in respect of their casual employees, the intention of which you glean from the legislation is that employees are regularly provided with these notices so they're aware of their casual conversion rights. The other aspect that was introduced through the reforms, and this occurred at the last minute through a request from the Greens, in particular Senator Pocock, who sought this change to the reforms in order to get the Greens' support But the bill, which is what occurred and has caused a lot of discussion, is this right to disconnect. So there's a right to disconnect that's been introduced through these reforms at the last minute. As passed, the right to disconnect will require that modern awards include a right to disconnect term with the precise wording to be determined, but it will, in general terms, provide for the exercise of an employee's right to refuse to monitor, read, or respond to contact or attempted contact from an employer or a third party, think client, outside the employee's working hours unless the refusal is unreasonable. The Commission will be able to issue determinations to vary modern awards already in operation to include this right to disconnect term. The reforms also include a general right to disconnect provision applicable to all employees in similar terms. This will act as a right rather than a requirement, meaning employees are not prohibited from responding to connecting out of hours if they wish. It's simply a right that they have if they don't wish to connect. Similar to the criteria for reasonable additional hours already set out in the Act, whether a refusal to respond is unreasonable will be determined by a multi-factor test, including an assessment of the reason for the contact, the method of contact, the extent the employee is compensated to remain available for working additional hours, the nature of the employee's role and their level of responsibility, the employee's personal circumstances, and whether the contact is required under a law. Again, there's a mechanism for dealing with disputes. The amendments introduce a process for dealing with such disputes, and if it doesn't resolve at the workplace level, an application can be made to the Commission to deal with the dispute. The Commission is empowered to make orders to stop refusing contact or to stop taking certain action, such as disciplining the employee for refusing such contact. In terms of contravening an order, a contravention of such an order constitutes a civil penalty contravention, and the government has also introduced a new bill to prevent employers from facing potential criminal penalties, which is an apparent mistaken inclusion in relation to these particular reforms. In response to these reforms, medical practices may wish to develop policy materials for managers and other staff that gives clear guidance on matters such as understanding urgency, the difference between contact by phone calls or texts versus emails, and maintaining an awareness of others' personal time, particularly parents and carers. For senior and executive staff, employers may wish to undertake a review of their employment agreements to ensure that an expectation for reasonable out-of-hours conduct is set out in a similar way to the way in which reasonable additional hours probably is included in their contracts at the moment. Turning now to the issue of the future. I describe the future as bespoke work. There is a report from the CSIRO which dates back to 2016 entitled Tomorrow's Digitally Enabled Workforce, which was produced obviously before COVID, and it notes the following changes occurring in our workplace in Australia: increased technological change, rapid growth of the freelance employment market, co-working facilities, and working from home. Of course, these trends have only been exacerbated by COVID. Over 4.3 million of Australia's 13 million workforce were working from home in March 2021. Over half of all workers in the finance industry and public administration were working from home at that time. Industries have increased their use of technology. Workers across the country have established home offices, providing a boom for companies like Officeworks. In a number of workplaces, workers have enjoyed these developments and wish to continue to work remotely. Employers are, with the current labour shortage, having to accommodate the desire of many workers in response to requests to work from home. Bespoke work is, based on this, likely to continue. Other aspects of bespoke work include the current discussion that's taking place about whether working from home should not just be, as it is at the moment, an ability to apply for under current flexibility arrangements, but whether it should also be a workplace right. And if it was established as a workplace right, that would potentially give workers the right to work from home, absent any business conditions or other criteria which an employer was able to rely upon it to refuse such a right. Senator Pocock, who introduced the last-minute changes in relation to the right to disconnect from the Greens, is also pushing hard for a 4-day working week. And that may well be something that comes onto the agenda in a more serious manner if Labor is looking for support in relation to any further changes to the Fair Work laws in the future. The other issue that I mentioned earlier in relation to the same work, same pay principle, that has been introduced, as I said earlier, in a very clumsy way. That is that an application must need to be made to the Commission in order to apply for a labour hire worker in order to get the same pay for the same work that their colleagues are doing who are not labour hire at a workplace. In relation to that issue, it seems to me that the next logical step that Labor might push for is to enshrine that as a right, as opposed from, and that would avoid the need for making application to have that principle applying to where they're working at any moment in time. And I suspect that's probably going to be the agenda in the not too distant future. So that's my guesses as to where we might be heading. But you can see from these reforms that there's some certain key elements that can be commented in relation to these. These are obviously significant reforms. The aims such as an increase to wages and gender equity are well-meaning. The non-stated aim, though, is to seek to provide greater relevance to the trade union movement through changes to enterprise bargaining rules and union representation rules. It remains to be seen whether these well-meaning aims achieve their goal or simply impose more red tape for employers who face the prospect of greater scrutiny of their decision as to matters, such as whether to provide flexibility or convert a casual employee to permanency by the Commission. And you can see that through each of these changes, a number of these changes that have been made, that where there is a dispute, the matter can then be referred to the Commission, who can then impose its decision in relation to the dispute, which of course fetters the rights that managers have in relation to making decisions at the workplace. The cost for employers of compliance mistakes, in particular paying incorrect employee entitlements, has risen sharply through these reforms, and now there's criminal implications in relation to errors that are made where these are found to be intentional errors. For medical practices, the time is right to review contracts, policies and practices to ensure they are compliant with these reforms. That's the end of my talk. Thank you very much for listening.